Okay, this is a continuation of Revolutionary Corner, Floyd's Revolutionary Corner Part 2. Okay, and dealing with the core of America is the Supreme Court. The core of America is the Supreme Court. Now, when you cast a rock into a body of water, from the center, ripples go out from the center and affect the whole body. It spans the whole body. Okay? And it affects the whole body. That ripple from the center, it expands and it expands and it expands until it affects and travels throughout the whole body. That is the Supreme Court. The Supreme Court is that ripple that it expands from the center, affecting and building, shaping and fashioning the mold of America. Now, recently you had ANTONIN SCALIA pass away. And what I'm about to do is go over a little of ANTONIN SCALIA's history and some comments of his and his feelings, okay, and his sentiments, because he sat on there for 30 years. 3 decades he sat on there, okay? And he is defined as a originalist, okay, and a conservative. And basically, an originalist is one who attempts to interpret the United States Constitution in accordance to what they believe the originators or the founding fathers or creators of the Constitution were implying, and their state of mind in real time when they was writing the Constitution, or when the idea hit them for whatever law they was writing down in black and white, So they try to interpret things according to real time as what the actual person was thinking, seeing, or feeling then. What was the purpose of it then? So they try to interpret it according to what they look at to be its quintessence or its purest form. Now, if this person is an originalist and trying to interpret the Constitution in accordance to real time or what the originator of the law that's being implemented, right, has been put down at that time, off top it automatically lets you know that it's not about to be any benefit for the blacks or the Africans in the land, because we were not at thought when that was created. So I'm just going to go over his sentiments and how he felt. Okay? And this is coming from the New York Times. Okay? This is a paper I've been holding down for a couple months. This is dated February 14, 2016. And I'm just going to read from it. Some of his recent comments from the bench were raw and provocative. In an affirmative action case in December, he said that some minority students may be better off at a less educated school, a slower track school where they do well. I don't think it stands to reason that it's a good thing for the University of Texas to admit as many blacks as possible, he said, describing. Some said distorted an argument in a supporting brief about the harm that could be caused to students with inferior academic credentials by admitting them to colleges where they do not thrive. Y'all want to replay this video when it get done. Replay it and let this stuff soak in and marinate. Another opinion. He served for 4 years issuing opinions favoring executive power, skeptical of claims of employment discrimination, and hostile to the press. The opinions, which were forceful and sometimes funny, attracted the attention of the White House. He was skeptical of claims of discrimination and dealing with employment. Who do you think was found in who do you think were the majority of claimants in discrimination of employment and filing these claims? It says faint-hearted originalists. The centerpiece of Justice Scalia's judicial philosophy was his commitment to the doctrine of originalism, which sought to interpret the Constitution as it was understood at the time of its adoption. That made him uncomfortable with some of the Supreme Court's most important precedents. This one right here really gonna get you. Justice Scalia also appeared to have reservations about Brown versus Board of Education, which struck down segregation in public schools as a violation of the 14th Amendment's guarantee of equal protection. Brown decided in 1954 is widely considered the towering achievement of the court led by Chief Justice Earl Warren. But for originalists, the Brown decision is problematic. The weight of the historical evidence is that the people who drafted, proposed, and ratified the 14th Amendment from 1866 to 1868 did not believe themselves to be doing away with segregated schools. In remarks at the University of Arizona in